No humans were harmed or even used in the creation of this program. We created it from a script written by the presenter using a generative artificial intelligence platform. We hope you enjoy it. Welcome to today's program, dealing with next-level negotiation tricks and bad faith tactics. My name is Zach McGee. I'm a Senior Vice President, Business Affairs for Sony Pictures Entertainment. Prior to joining Sony Pictures, I was an in-house lawyer at NBC Universal, and before that, I was a lawyer at Davis Polk. I've been writing and speaking on legal education topics for the past 20 years, including having taught a course on legal ethics at Pepperdine Law School. As you might expect, I am speaking today solely on behalf of myself, and my views don't reflect those of my current or any former employers or institutions with which I've been affiliated. This program is the third program in our Negotiation Ethics for Lawyers series. If you enjoy it and would like to view more programs in this area, we have quite a few more to offer you, and those additional programs most likely are available on the same service where you are watching this one. Our first program is an introduction to the topic of negotiation ethics for lawyers, and our second program followed that up with an examination of several common negotiation dirty tricks that the other side might attempt to use against you and focuses on how you should respond without violating your own ethical obligations. Today's program follows the same approach, but focuses on the sorts of dirty tricks and bad faith tactics that the most sophisticated parties might employ in their efforts to obtain an advantage in their negotiations with you. You can think of it as a more advanced version of our second program, a masterclass in negotiation ethics and strategy, if you will. Our next two programs are probably the most fun because we look at how negotiations are portrayed in two amazing Hollywood films, and we take lessons from those negotiations that can be applied to real-world negotiations that you might have in your legal practice. Our sixth program discusses paltering, which is defined as the active use of selective truthful statements to mislead as a negotiation tactic, and considers whether paltering by lawyers violates the legal ethics rules. Finally, in our latest program, we return to our roots and analyze even more dirty tricks that the other side may try to use against you in your next negotiation, and how you legally, ethically, and strategically can respond to those tactics. I also should mention that for California lawyers, who are now required to complete 1 hour of civility in the legal profession CLE credit, we have a program entitled Civility. Do lawyers have a duty to negotiate in good faith? That is an honorary member of our Negotiation Ethics for Lawyers series because it discusses whether California's non-binding civility guidelines impose a duty on lawyers to negotiate in good faith. As you might expect from our robust offering of programs in this area, negotiation ethics is a popular topic. I think that is so because not only are lawyers looking for guidance on how to make sure they comply with their legal ethics obligations when they negotiate, but also because they feel that they need help in terms of knowing how best to respond when they believe that the other side is acting unethically. If that describes you, then you've come to the right place, and I hope you take advantage of this program and the other programs that we have available in our Negotiation Ethics for Lawyers series. So we're going to do 3 things today. First, we're going to talk about some next-level negotiation tricks and bad faith tactics, how to spot them and what you ethically can do in response if somebody is using these negotiation tricks against you. Second, we're going to review the legal ethics rules that apply to lawyers in the context of negotiations. Third, we're going to teach you some powerful strategies that you can employ when these negotiation tricks are attempted to be used on you in order to help you deal with the situation in the moment while at the same time complying with your own ethical obligations and providing the best possible representation you can for your clients. By next-level negotiation tricks and bad faith tactics, what we're talking about here are the sorts of tricks that sophisticated parties, large companies who may be represented by highly experienced business people and lawyers, might use to try to obtain an advantage in a negotiation against you and your clients. Now notice I didn't say obtain an unfair advantage, and I'm being careful about that. Unlike, let's say, for example, the game of poker, negotiation often doesn't have a clear or universally accepted set of rules that sets out what is right and wrong, what is fair and unfair. Again, sticking with poker, everybody knows in poker that bluffing is perfectly acceptable, and in fact, it's often considered praiseworthy. People say, wow, what a great bluff that person made in that particular hand. But there is a difference in poker between bluffing, which is clearly allowed, and pulling an extra card out of your pocket from another deck and inserting that into the game, which is not allowed. That's clearly cheating and a violation of the rules of poker. Negotiation is not like poker for that reason. We don't all agree on a set of universally accepted rules for negotiation, and that's why the use of some of these negotiation tricks can be a little bit intimidating for someone who doesn't have a lot of experience with negotiating, or maybe even if you do, because you're also a lawyer who is mindful of your ethical obligations. We're going to talk about what some of those ethical obligations are here today to give you some guidance about what you can and can't do in a negotiation. But at the outset, it's important to recognize that when you look at one of these tricks and say, hey, that's completely unfair. I can't believe somebody's doing that to me. That's unethical. Someone else may view it as completely acceptable in the context of a negotiation. That's why it's important to remember that not everybody agrees on exactly what's fair and unfair. That is not to say that there aren't some universally recognized and accepted rules that apply to negotiation. It's not completely the wild, wild west, as they say. Obviously, there is the law of fraud, and that applies to everyone. And then for lawyers, there are also additional rules that come from the rules of professional conduct. Taken together, it is the law of fraud and the legal ethics rules that collectively define what is fair, meaning legal, and what is unfair, meaning illegal, and in the case of lawyers who are bound by those rules, you can add to that unethical. But what we find is that aside from a few black-letter rules, there's really a gray area, and that most negotiators, particularly the most experienced and sophisticated ones, operate in this gray area. And within that range, there's a lot of conduct that one negotiator would regard as perfectly appropriate, perfectly fair, perfectly within that party's expectations, or what should be within that party's expectations, while the same conduct is seen by others as falling completely outside that line. It's precisely because people approach these things differently in this gray area that many people dislike negotiating because they don't know what they can reasonably expect, including whether their good behavior will be reciprocated by the other side. So one of my goals here today is to help lawyers survive and even thrive in this gray area of negotiating on behalf of clients. I will do that by making you more comfortable identifying the types of conduct that fall on the inappropriate end of the spectrum, conduct that is on the other end of the spectrum in terms of being clearly appropriate, and where the lines can be drawn in the middle. I also will give you some techniques to help you respond when you face conduct that you are concerned may be on the wrong side of the line. I think that's the right way to help you achieve the best results for your clients, because there is no judge or state bar official to call balls and strikes in your negotiation. So in that sense, you are on your own anyway, while making sure that you understand where the lines are, so that you are not finding yourself in a position where your conduct could be questioned as crossing one of those lines. Before I introduce our hypothetical and we begin discussing some new material in terms of next-level negotiation tricks and bad faith tactics, in our last program, How to Recognize and Respond to Dirty Tricks and Bad Faith Tactics, I discussed and analyzed a number of common dirty tricks that people use in negotiations. And of course, I talked about what is a dirty trick or bad faith tactic for one party in a negotiation may well be considered by another party not to be a dirty trick or bad faith tactic. I recognize that when I use the phrase dirty trick, I don't necessarily mean to suggest a conclusion that it is in fact across the line. I just use it to refer to a category of tactics that some people that you are negotiating with may find questionable or that you may find questionable. Here's the list of dirty tricks and bad faith tactics that I discussed in our last program, so you can get a sense of how this works. I talked about the tactic of take it or leave it. Some people refer to this as making threats or playing a game of chicken. I talked about the tactic of simply lying or making up facts that relate to the negotiation that you think will move the other side, or the other side thinks will move you. I talked about misrepresenting one's true goals or objectives in the negotiation. I talked about delay and timing tricks that parties play to try to influence or exert pressure on the other side. I talked about one particular timing trick called the slow no, where a party doesn't say no for a very long time until it can potentially prejudice the other party. And lastly, I talked about perhaps the most famous dirty trick of all, the good cop, bad cop. Not that any one of these are terribly uncommon or hard to identify. but I thought it was helpful to categorize them and look at them specifically. So how did we approach the dirty tricks and bad faith tactics that we discussed in our prior program? First, we talked about whether the tactic or trick actually violated any rules of legal ethics, and we talked about what those ethical rules are. We then talked about, and maybe this is as important, how does a party respond when faced with conduct that they believe is unethical? And the idea is to respond not just effectively, but also in a way that doesn't itself violate the law of fraud or the rules of ethics. I think this is a good way to impart this information to an audience of lawyer negotiators, and I'm going to follow the same approach here today. The main difference is that I'm going to talk about a different level of tactic or trick, and I've referred to them as next level tactics or tricks. And you should think about these as being tactics or tricks that you might expect to be employed by a more sophisticated party. You may think that necessarily means a larger company or a company that is represented by experienced negotiators who are more likely to engage in sharp practice. Those are probably useful ways to think about it. You are going to encounter these types of tactics and tricks when you deal with more sophisticated parties who have more experience negotiating. We're going to follow really the same approach in our discussion today. We're going to talk about the conduct. We're going to try to identify the tactic or trick and give it a name so that we can deal with it and talk about it. We're going to consider whether the conduct actually violates any of the rules of ethics. And then I'm going to give you some concrete and practical advice on how you might respond in a legal and ethical way if you're faced with this conduct in a future negotiation. With that background, let me introduce the fun hypothetical negotiation between lawyers that we are going to use for today's program. In our hypothetical, we have an aspiring television producer and current coffee shop server, Alfonso Spears, who has an idea for a new reality TV show called Puppy Love.
My concept is that after an eccentric widow leaves her fortune to her prize Labradoodle Kiki, 6 contestants compete to win Kiki's love, and with it, her $5 million inheritance, and like all good treatments and pitches, it ends with hilarity ensuing.
Ricky, aka Slick Rick Stratton, owns an upstart reality TV production company, Silver Spoon Productions. Flush with success from his breakout hit Your Dingo Ate My Baby, Rick is always sniffing around for his next project.
Over a decaf, skinny, no foam latte, I invite Alfonso to pitch Puppy Love, and I accept a detailed written treatment from Alfonso.
Not entirely surprisingly, Alfonso never hears from Rick again, and that fall a show called Dog's Best Friend premieres on the Animal Network. The show, which is produced by Rick and Silver Spoon, is oddly similar to Alfonso's concept for Puppy Love. What does Alfonso do? He hires Kate Summers, who is an industry litigator and a self-proclaimed legal pit bull, to represent him in this dispute with Silver Spoon.
In a barking letter, I accuse Silver Spoon of stealing Alfonso's idea for Puppy Love and insist that Alfonso receive proper creative credit on Dog's Best Friend, a salaried producing job, and a healthy share of the show's profits.
Silver Spoon is represented by its sole in-house lawyer, Edward Stratton III, who happens to be Slick Rick's brother.
I counter that Dog's Best Friend was created independently from Puppy Love, and the similarities aren't enough to state a legal claim against Silver Spoon anyway.
Kate and Edward are now negotiating to try to resolve this dispute between Alfonso and Silver Spoon. Lastly, and importantly, while each is an industry veteran, they do not deal regularly with one another. This touches on something that I'll mention again later, but for now, I want to highlight that we've purposely created a situation where these folks are not going to deal with one another often. And the reason we've done that is because you tend to see sharper practices when negotiators are not concerned about facing one another later. Obviously, to the extent that these people dealt with one another regularly, their conduct would be probably more circumscribed, more reasonable. They would be more concerned about their reputation. They would be concerned about any deceptive practices not being effective and therefore preventing them from competently representing their clients. So it's important to note that they don't expect to see each other again, and I think that's going to explain a lot of the conduct that we see later. With that introduction, let's dive right into the first hypothetical.
I can't agree to any settlement that involves hiring your client as a producer on Dog's Best Friend or giving him a producer credit, even if he doesn't render any services on the show. Our studio has a strict policy against rewarding people who claim we stole their ideas, so I'm afraid those options are off the table.
The ethical issue here is that this is only the second time Silver Spoon has been accused of idea theft, and the studio has no policy written or otherwise requiring how such claims are to be resolved. This next level trick is called lying about your company policy, or in this case, making up that you have a policy when none in fact actually exists. I'm sure many of you who are watching today's program have had this happen to you. Someone on the other side says, "Well, I can't agree to that because we have a company policy." It's pretty common. It doesn't mean it's not the case, but the other flavor of this is either making up a policy that you don't have, or maybe having a policy but perhaps not following that policy. Anything in that range is really what I'm referring to when I'm talking about lying about company policy. What is happening with this trick is that you are being presented with a policy and you are being told it's the reason that the other side can't agree to what you're asking for, but maybe you know, or maybe you just suspect that either that's not what the policy is or that they've made lots of exceptions. And when people make lots of exceptions to a policy, it's really the same thing as not having a policy at all. In other words, you're making decisions on a case-by-case basis. And if that's the situation, then the other side should be engaging with you on your requests in this negotiation, and you should decide whether this is a case where that policy should apply or it shouldn't, rather than simply trying to shut down that negotiation by claiming that their hands are tied by some policy. That's the trick that I want to talk about first. So first we ask the question, is Edward's conduct here ethical? Let's start off with the general proposition that lying is generally considered to be morally wrong. So first you have a moral issue. Acknowledging that people draw moral lines in different ways, people use various tests for whether something feels like it's on the right side or not when it comes to simple morality. And one test that you'll commonly hear is, how would you feel if you were engaged in this conduct, describing it to a person whose judgment you respect? So maybe a mentor or a friend you look up to, or in my case, I keep it simple. I imagine trying to explain to one of my daughters why I am engaging in that conduct, and I try to imagine the look on her face as to whether she would think that was appropriate or not. For example, how is it okay for you to lie in business, Daddy, when I'm not allowed to lie about how that stain got on the sofa? So we try to hold our conduct up to the right standard, and the problem is in the heat of the moment you can think that whatever your goals are, they are so important that they justify crossing lines or at least coming very, very close to those lines. And I think envisioning how explaining yourself would come across to a neutral, disinterested observer whose judgment you respect and how would you feel describing it to them is a very good way to think about it. Lawyers may take a lot of grief in the field of ethics, but I like to point out that lawyers are some of the few people who are actually subject to specific ethical rules that govern our conduct. And I think it's incumbent on us, frankly, to not perpetuate the stereotype of lawyers as people who are somehow trained to lie and obfuscate. Second, I think you've got a very practical issue here, and that is, if Kate uncovers Edward's lie and exposes him, then Edward's reputation will suffer for it, and that's going to make it much harder for Edward to do business in the future. You're going to be dealing with a lot of the same people in your practice over and over again. I work in Los Angeles, and you might think, well, that's a huge metropolitan area. I'm sure there's hundreds of thousands of lawyers. But in reality, it's a pretty small community when you are talking about the entertainment industry. It's rare that I deal with somebody that I don't know or where I don't know someone who knows that person, and if you get a reputation in your community for sharp practice, that could really be a detriment to you and to the clients you represent. Let me explain what I mean. If I'm negotiating with someone who I know has a reputation for sharp practice, I'm going to be extra careful with that person. There might be reasonable accommodations that I would make for people that I deal with regularly who I feel are straight shooters. With some of those folks, I could get a deal done in a day and feel comfortable relying on an email confirmation even before the contract is done because I know and trust them. If I don't trust you, I will make you document every statement you make to me that I can't independently verify before I will rely upon it, and that process can take a very long time. I'll also likely take a harder line against you if I believe you are a shady negotiator, because I expect you will be doing the same in your dealings with me. If this type of negotiation takes longer than your client wants and ends up delivering less value to your client than another lawyer could have obtained, you will end up being less effective for your client precisely because you have a reputation for sharp practice. So there's a practical downside to telling a lie here, meaning that it may not even serve the interests of the party engaging in the lie. So let's step aside for a moment from the morality of lying and from the practical risks to one's reputation, both of which we've talked about, to examine the legal considerations. As I mentioned at the outset, there's the law of fraud, and there are legal ethics rules that collectively govern our conduct when we negotiate. But here's the problem. They don't expressly prohibit all forms of lying. This is where the gray area comes in, particularly when one imagines that lawyers have a duty of zealous advocacy on behalf of their clients. You can imagine the tension there when the law allows certain types of lies on behalf of a client in a negotiation, and you are also faced with the duty of zealous advocacy. It makes for some real tension between the two. The problem with a lot of these rules is that when you talk about the law of fraud, you're talking about only material misrepresentations, which means that representations that don't rise to that level are not caught by that law. In the case of fraud, you're also talking about misrepresentations that the other party actually relies upon to their detriment and suffers damages. That's a pretty high bar, and it's a pretty difficult standard of proof, as we all know. It's important to know that there are legal ethics rules, though, that don't require the same high bar in order to find that the conduct in question was inappropriate. So, for example, fraud requires materiality and detrimental reliance, among other things. The legal ethics rules, specifically ABA Model Rule 8.4, prohibits lawyers from engaging in conduct involving dishonesty, do not always have a requirement of materiality. For lawyers practicing in California, and this is often a surprise to people, Business and Professions Code Section 6068 requires that lawyers employ those means only as are consistent with truth. When you read that on its face and it's not qualified, and there are no footnotes, and to my knowledge no case has interpreted that particular provision to create any exceptions for negotiations or otherwise, it suggests that any lie or obfuscation could potentially be a violation of the ethical rules for California lawyers. Now that's pretty extreme. Most of the other rules that we're going to talk about, including ABA Model Rule 4.1, and there's a specific ABA ethics opinion on lawyer negotiators, it's ABA ethics opinion number 06-439, take a more liberal view of what conduct lawyers can engage in before they cross the line. In general, they suggest that negotiation conduct is only unethical if a misrepresentation is knowingly made, and if the misrepresentation is one of material fact or law. So you need to analyze very carefully what Edward actually said in order to see whether his conduct violated the law of fraud or the legal ethics rules. Let's take Edward's statements one by one. The first statement that he made was that he can't agree to a settlement that includes certain things. So the first question is that a statement of fact? And I think properly construed, this is not a statement of fact. It is a statement of a party's intention. And once we put it in the category of a statement of intention, then you go look at the ABA model rules, and it turns out that the model rules, and specifically the ABA ethics opinion, expressly state that a party's intentions as to an acceptable settlement of a claim are not statements of material fact. Now, not everybody would agree with that. Somebody could say, if I tell you what my intention is and my intention is A, and I tell you that it's not A, haven't I actually misrepresented a current fact? Now we can get into issues of problems of proof, and how would one ever know? And those are probably lurking in the background in terms of why we don't make that type of conduct unethical. But the ABA simply came out and said, it is not unethical to lie about what you'd regard as an acceptable settlement. I think most people would be okay with that. Not okay with the idea of lying, but it's so difficult to prove what someone's intention may be. And I don't think that most people expect that the other side is giving them the unvarnished truth when they talk about what would or would not be acceptable in terms of a potential settlement in the context of a negotiation. Think of the plaintiff's lawyer who insists that his client won't accept less than $1 million and who settles 2 hours later for $25,000. Sad as that may be, I think that's just the reality that people don't expect truth there. So I think the first statement is not a false statement of material fact under the law of fraud or the legal ethics rules. Let's take a look at the second statement, which is, our studio has a strict policy against rewarding people who claim that we stole their ideas. That's a harder one. It's clearly not a statement of intention. It's a statement as to a fact that theoretically exists or does not exist at the time that the statement is made. But let's look at this comment here. Our studio has a strict policy. That's actually a little bit more vague, and of course we're lawyers, so we're trained to look for the ambiguity here. What does it mean that you have a strict policy? I don't think he means that there's a written policy. I don't think he's going to get out an HR manual or a standard of business conduct guide that's going to have a policy that says we don't reward people who claim that we stole their ideas. I think probably what he's talking about is a practice or a course of dealing, and the word policy may be shorthand for that. They may have had discussions and meetings about, geez, it wouldn't be a good idea for us to reward people who are making false accusations against us. If you think about it, in a sense, doesn't every company have a policy of not rewarding people who claim that they stole their property? My sense is that what Edward said is so generic and vague that it's fairly meaningless. I don't think that's going to either be actionable under the law of fraud or be a violation of the ethics rules. So that's how we deal with those two statements in terms of analyzing whether they are ethical or not. But as I said at the beginning of the program, we're talking about next level negotiation tricks here. And I think it's pretty fair to say that these statements qualify. I think they come fairly close to the line. Notice what Edward was careful not to say. He did not say, we do not hire claimants as producers, or we have never hired claimants as producers. That would be a very specific fact that could be verified and could be material, could be knowingly made, and it could clearly cross the line. He did not say that they have never given claimants credit as producers. Why wouldn't he say that? I think the reason he didn't say it is because he knew that if he made that kind of a statement, it potentially could give the other side a claim for fraud and open himself up to an ethics violation if it were false. What he did instead is he coupled two statements together that were aggressive in order to create a very false impression. He took a statement about what kind of settlement he would or would not be willing to accept, and a statement about having a strict policy to create the impression that Silver Spoon actually had a policy or a past practice of not hiring claimants as producers or giving them credit. He also refers to these two options being off the table right after he refers to Silver Spoon's policy. But again, he doesn't say expressly that the company has a policy that bars it from agreeing to either of these options. You can tell that by linking these statements to give that impression without expressly saying it, Edward is a smart, tricky, and arguably dirty negotiator. But in this case, he's probably managed to pick his words very carefully and sequence them in a way that doesn't cross the ethical line in terms of getting him into trouble with the state bar or expose Silver Spoon to a claim for fraud. Although one could argue that when combined together, all of these statements created a very false impression, and we have seen cases in which that reasoning has been used to declare conduct to cross the ethical line, so Edward might have some risk here, as careful as he is. Let's think about how Kate might respond, which is just as important. What do you think Kate could do or should do in this circumstance? Before we talk about a possible response, one of the things about lawyers that frankly can be our downfall is that we're smart people, right? I mean, you have to be smart to get to law school, to do well there, to pass the bar, and to become a lawyer. One thing that smart people do is you infer things. You infer from X, Y, and Z facts that you know, and then you quickly leap to whatever that next thing is. It's extremely dangerous to do that, particularly in the context of a negotiation, because what a skillful person on the other side will do is exactly what Edward did here. They won't say that our company has a policy against hiring claimants as producers, or that we have a policy against giving someone a producer credit who doesn't render services. They will say, we're not going to agree to that. And we have a policy against rewarding people who sue us. And by putting the two together very closely, you're immediately going to leap to, oh, the policy is about that thing he just said. So it's really, really important to focus in a negotiation on what is actually being said to you and to try not to take that second leap. A mentor of mine many years ago was famous for saying, never assume a goddamn thing. And I think for lawyers, it's very smart advice. Sometimes, as smart as you are, you don't focus on the details and you try to immediately leap to the next thing. So what could Kate do in response? There are many things she could do. Probably the best way to respond to an argument based on company policy is to ask a lot of questions. And certainly don't accept the stated policy at face value. Let's take a look at how this can be done very effectively.
That's interesting. What exactly is Silver Spoon's policy? How long have you had this policy? And have you ever made an exception to it?
If you're an experienced negotiator, or perhaps you're someone who's seen one of our prior programs, You'll know that asking questions is a great way both to detect deception in a negotiation and to counter it. With a few simple questions that Kate has asked here, she's effectively boxed Edward into going down one of two roads. The first road is for Edward to quickly recant and to say, "Oh, well, we don't have a formal policy," etc., etc. And then Kate immediately knows that this was all a sham and just a negotiation trick. And you've essentially neutralized that part of Edward's argument. The other road that Edward could go down, of course, is to double down and to start talking about, well, yeah, the policy specifically says that we can't do this, that, and the other thing, and we've had this policy for years, and we've never made an exception to it. If Edward goes down that road, it's also beneficial to Kate in that she has now gotten Edward to make several affirmative, false statements about his company's alleged policy, what it says, and the fact that they've never made any exceptions. Those lies could be very useful to Kate, either as leverage later in the negotiation or after a deal is done, if there's a reason Alfonso may want to set aside the deal. She would now have the ability to point to these specific falsehoods, and she would argue they are material, knowingly made false statements that Edward made about company policy as a way to potentially undo that agreement after the fact, claiming fraud. It's not to say that she'd succeed necessarily. I mean, the standard for fraudulent inducement is reasonably high. And whether or not knowingly false statements about company policy as to what they've done in prior cases would be enough to actually get Alfonso out of this contract. That's not clear, but it certainly would give Kate the ability to credibly threaten something like that. And that might be enough to get whatever relief she's trying to get. Asking questions is a terrific way in a negotiation, both to counter the specific next-level negotiation trick of lying about company policy, but just generally, anytime you think someone is telling you something that isn't entirely accurate. The more questions you ask is going to force them into that Hobson's choice of immediately recanting or doubling down on their lies. Interestingly, we're talking about someone being on the opposite side of an argument for company policy. Let's take a second to think about it from the side of the lawyer who's arguing from the policy, because I think it's interesting enough to spend a minute talking about it. And it raises an interesting question because those of us who have been in big companies, you often do have lots of company policies, many policies sometimes. And a lot of times in a negotiation, you're tempted to, or really required to, reference your own company's policy in response to some ask on the other side. I think this can be difficult because in a large company, it's really impossible for you ever to know whether the company has ever made an exception to a policy. I mean, you're just one person working in one particular division. There are people working in many different divisions, potentially all over the world. And so for you to say that we have never made an exception to that policy, I think there's a lot of risk there for any individual negotiator. And certainly if you know that exceptions have been made, then you're just being Edward if you do that. If you say, well, we don't make exceptions, when you know that you have, then you are simply lying. I think the best way to argue based on company policy, at least in my experience, is to be truthful, of course, about what the policy is. So say, this is our policy, and then to speak only about your conduct, whether you yourself have made exceptions to it, and to really disclaim any knowledge of anyone else. I mean, certainly if they ask, you could say, I don't know what others in the company have done, but I've never made an exception to our policy, and here's what it is. That way, I think you get the full benefit of the policy, the fact that you have it, without really incurring any of the downside risk. Now, what's interesting also is these policies can range from the trivial to the critical. So my examples here are one company I used to work for had a policy about never giving the other side a Word version of an agreement, only PDFs. The stated reason for this policy was metadata. We don't want to give you a Word file because maybe you could figure out what the prior draft looked like, etc. I think the real reason behind those policies often is you want to discourage comments and extensive markups, right? And it's a negotiation tactic, but it's also, in some sense, not crazy in that a lot of big studios will have their quote-unquote form, and you're not going to be able to rewrite that form anyway. So, it would be a waste of your time to take my draft and rewrite it, and the better practice is that you comment on it. And then, if there's a change that the studio is willing to make on a provision in the contract where you've made a comment, you get the studio's approved give language on that point. So not a crazy policy, and it's often intended to discourage a lot of rewriting or comments that aren't going to be accepted anyway. I would put that in the trivial box. In the mission critical box, I would put policies about what we call DRM, or digital rights management, anti-piracy requirements that a studio always insists upon, and in fact, the studio will not license TV or film content to anyone who doesn't meet the studio's set of required DRM policies. That is in the mission critical category. So you have this range of policies that you may be required to reference and to follow. You may be very tempted in a difficult negotiation to shade the truth about whether an exception has ever been made to either of those policies. Maybe it's a high-level producer that you know you've given the word version to, just because you can't say no to that person's agent or lawyer. But maybe it's on the other end, where it's the mission-critical policy at issue. And if somebody's saying, hey, have you ever made an exception to your DRM policy? You might be willing or tempted in that case to say, no, we've never made an exception. When you know that you have for your largest and most important customer, because it's so absolutely critical to get agreement on it from almost everyone else. My advice is just to stick to truthfully describing your policy and only whether you yourself have made exceptions to it. If you do that, you're going to be on firm ground when you argue based on company policy in a negotiation. Another way to approach this is to follow a simple rule, which is this. If I make a representation to someone about what we have done or what we have not done, not only would I be prepared for them to ask me questions about what I just said, and I would be prepared to answer truthfully in a way that would show that what I had told them originally was truthful. But what if they came back and said, wow, that's really interesting. You've never made an exception to this. Naturally, that's an important fact for me. If I can go back and tell my client that you've never done this, that's going to be material. That's going to move them. So you won't be surprised then when in the agreement it recites at the very beginning, whereas you, the company, have never ever done this before, and whereas that is material, and whereas I'm now going to rely upon that statement. We will agree to this term. And oh, by the way, if it turns out that that is not in fact true, if you have ever made an exception, then the exception applies to us as well. And by the way, you have an affirmative obligation to raise it. And by the way, maybe there's a penalty. So if you think about that, you see the logic of my suggestion, which is, geez, I don't know. I've been here a long time. I've done a lot of these deals. I can't think of a single example where we agreed to it. I suppose there's always a first time, but I would be very surprised if anyone here wanted to agree to that. It's a much safer approach. I mean, first of all, you're not going to lie and overstate it if you're wrong, right? Let's assume you don't know, but you don't put yourself in that position. And I've also just hinted at one of the things that you can do when you're faced with somebody who's making this broad representation about a company policy or what they've done. You say, great, if that's your policy and your company has never made an exception, then you won't mind confirming that for my client in writing. And imagine you don't know what people have done maybe in another office or in another context, and it's just too great of a risk to put on yourself. So don't overstate what you know to be the case, and that's how you stay out of trouble. Let's take a look at the next hypothetical.
I can't agree to any settlement that involves hiring your client as a producer on Dog's best friend or giving him a producer credit, even if he renders no services on the show. We never agree to either of those things, and I'm not about to start now.
What is the ethical issue here? Well, in a prior idea theft case, Silver Spoon hired the claimant to help them produce the show, but did not give him a producer credit as part of settling the claims. Because that claimant did not receive a screen credit, and because the settlement agreement he signed contained a confidentiality clause, Edward knows Kate is highly unlikely to find out any of the terms. So what's the problem here? Well, the problem here is lying about other deals. And I just want to use that broadly as a category. Of all of the things that I personally have faced in negotiations, this can be one of the most frustrating next-level tricks when parties are lying about other deals. And it actually comes up in a lot of different contexts with a couple of different flavors. One of them is, I have to get this term with you, whatever term the other side wants, because we always get it. So they're implying that every other deal has that term. And we just talked about that a little bit. The other flavor is, we can't give this particular term that you want because we never give it. Or a little bit more subtle version of it is, we can't give you that term because it will trigger our other agreements. Which is really code for, maybe there is an MFN or most favored nations clause in another agreement which potentially could be triggered. Of course, you'll never know that, you can't verify it, but people will potentially misrepresent what exists in other deals. And then a third flavor is, we need to do a deal with you, or we need to advance this deal that we're talking about, because we're getting very close to agreement on these same terms with others. So if you think about it, all of these fit into this category of some other deal that the other side has done or is working on, and they're making a representation about it, and it's designed to move you in their direction. So the three versions are, I have to get this term from you because I always get it. I can't give you the term you want because I never give it. Or the alternative, I can't give you the term that you want because it's going to hurt me in some other deal. And finally, I need you to move more quickly and come further in my direction because we're getting close with some other party. All of these are lies or misrepresentations that concern other deals. Let's start by considering, since we're here to talk about the legal ethics rules, whether Edward's conduct is ethical. We all know it's frustrating, but is it unethical? Our analysis of whether Edward's conduct is ethical once again begins and ends with what he actually said. Once again, Edward is being clever and he's being tricky. He's saying some things from which he thinks Kate will infer something that he actually didn't say. So let's parse it. What I'm trying to do with this program and with these hypotheticals, in particular with next level type tricks, is to shine a bright light on the tricks that sophisticated parties will try to use against you to try to obtain an advantage in the negotiation. And you really need to be very cautious. And that's what I'm hoping these hypotheticals will lead you to realize and lead you to be on guard in your own negotiations, particularly as the stakes that you face in those negotiations get higher and higher. Here, Edward says that Silver Spoon has never hired a claimant as a producer on a show or given a claimant a producer credit, even when he didn't render any services. So the second piece of that, in terms of never giving the producer credit, that's true. We know from the description that that didn't happen in the prior case. But what about the fact that in that prior case, they hired this claimant to help them produce the show? Isn't that the same thing as hiring them as a producer? Now, without getting into too much entertainment industry inside baseball, the two are actually different, or at least they're arguably different in the sense that in this system, what matters in terms of whether you are a producer or not is what your personal services contract with the studio says. If the studio's contract with you says that you're hired as a producer, you are a producer. And often, not always, but generally that will come with receiving some type of screen credit as a producer. And the level of that producer credit would depend on your level. Executive producer, co-executive producer, etc. In the context of reality TV in particular, it's even a little murkier because there are no guilds. You don't have a WGA or a DGA or SAG-AFTRA specifying what level or title someone has to have based on what services they provide. And again, not trying to get off track, but just to explain, in a reality TV show context, you can hire somebody to do pretty much whatever you want them to do and call them whatever you want to call them. And so even if this prior claimant performed services for Silver Spoon that were similar, even identical, to services that are customary of producers in the industry, they could have called him a writer. They could have called him a consultant. They could have called him whatever they wanted. And assuming Edward was careful enough in the contract with that person to call him something other than a producer, he hasn't actually lied about that term. He certainly has misrepresented it in a way to suggest that there was no business relationship between Silver Spoon and that prior claimant. In connection with the show, that person claimed Silver Spoon had stolen. So again, you're faced with a very clever counterparty who didn't technically misrepresent that prior deal. While being technically accurate, there can be little doubt that Edward is being purposefully misleading here. But is a purposefully misleading but literally true statement enough to hold Edward liable under the ethics rules? In order to answer the question, you need to distinguish the two bases on which you might consider the conduct to be unethical. And one of them is, in general, is there a duty to negotiate in good faith? Number one. And two, can a partially true but misleading statement be the equivalent of an affirmative false statement? So I know we started off saying there's all this gray area. Here, we actually have a couple of pretty clear answers. The answer to the first question is that, in general, in the United States, absent a specific contractual duty to negotiate, there is no duty to negotiate in good faith. The answer to the second question, about whether a partially true but misleading statement can be the equivalent of an affirmative false statement, is yes. So let's go look at each of these concepts. Do lawyers have a duty to negotiate in good faith? The short answer is no. The longer answer is that in general, in the United States, there is no independent duty to negotiate in good faith, because neither the law nor the legal ethics rules require the parties to negotiate in good faith. We do need to distinguish a few things. If you're under a contractual duty to negotiate, let's say you have a first negotiation provision in a contract, or a duty to negotiate an extension, for example, the law would imply a duty of good faith in the performance of that contractual obligation. As we all remember from first-year contracts, the law implies a duty to perform all contractual obligations in good faith, which then would include contractual duties to negotiate in cases where such a duty is part of the contract. But that's a specific case, and absent that, there is no general duty to negotiate in good faith. Now that said, there are two caveats to this. The first caveat is that we're talking here about U.S. law and law in the various U.S. states. In some European jurisdictions and in China, for example, there can be a general duty to negotiate in good faith. The other caveat is there are some aspirational guidelines, including some published in California, about civility that do suggest that lawyers should act in good faith when they are negotiating. But that is not something that is binding on lawyers. The ethics rules, as we'll see in a second, plus judicial decisions interpreting those rules are the things that bind lawyers, not these aspirational guidelines. Setting those caveats aside, the fact that there is generally no duty to negotiate in good faith is a point that's very often misunderstood among lawyers and even some judges. Lawyers often levy charges against one another of negotiating in bad faith, but usually they're just describing some conduct that they don't like or that they find takes a sharp edge, and it's not really talking about a violation of some independent duty to negotiate in good faith. There is no independent duty absent a contractual obligation to do that in the United States. Because many of you are California lawyers, and also because what the California State Bar decides to do often influences the actions of state bars of other states, I should take a few minutes to explain what California's civility guidelines are in general and what they say with regard to negotiation in particular. About 15 years ago, the California State Bar adopted the California Attorney Guidelines of Civility and Professionalism to address a perceived lack of civility in the legal profession. The guidelines consist of 21 sections that address civility issues in client relations and responsibilities to the profession, public and administration of justice, in addition to civility issues and responsibilities in attorney-attorney relationships. One of those sections is Section 18, which provides that an attorney should negotiate and conclude written agreements in a cooperative manner and with informed authority of the client. Section 18 follows this general pronouncement with the additional guidance, including several specific examples of behaviors it advises lawyers to avoid when negotiating, including Example C that covers the negotiation process itself. Quote, an attorney should avoid negotiating tactics that are abusive, that are not made in good faith, that threaten inappropriate legal action, that are not true, that set arbitrary deadlines, that are intended solely to gain an unfair advantage or take unfair advantage of a superior bargaining position, or that do not accurately reflect the client's wishes or previous oral agreements. End quote. So, Section 18 of the guidelines expressly encourages California lawyers to negotiate in good faith, in addition to setting forth a number of specific things that it says lawyers should not do when we negotiate, such as setting arbitrary deadlines or using negotiation tactics that are abusive or are intended solely to take unfair advantage of a superior bargaining position. Because there is no legal duty to negotiate in good faith in most situations, the California State Bar's aspirational guidance is very different from what the existing law and legal ethics rules actually require of lawyers when we negotiate. While the California State Bar very much would like you to follow its recommendations in this area, it's critical to understand that the guidelines reflect how the California State Bar thinks lawyers should practice law. They do not create standards of conduct or care. They do not supplant any rules or laws that govern attorney conduct, and they cannot be an independent basis for imposition of discipline or a finding of malpractice. Even if you are a California lawyer, It is entirely up to you whether you choose to follow the California State Bar's advice that lawyers should negotiate in good faith. If you are a lawyer who practices in any other state, these aspirational guidelines are even more aspirational. But I think it's useful for all lawyer negotiators to be aware of them and consider whether you should strive to negotiate in good faith, even if you are not legally or ethically obligated to do so. In my view, it's a better practice to negotiate in good faith. You're going to have a better result. You're going to form better relationships. You're going to have better encounters with those people later. The contract is more likely to go smoothly if the negotiation process has gone smoothly. So I think the take-home message here is, for all these reasons, engaging in bad faith just to get a capitulation essentially may not produce A, the best agreement, or B, a durable agreement, that is, one that isn't going to be challenged later, isn't going to be the subject of a claim, or just isn't going to be performed well by the side who feels that they were taken advantage of by some bad faith negotiation. Let's look at the second question, which is, what happens when you make statements that are misleading? They may be partially true, but they're definitely misleading. Well, here, the ABA model rules enter the scene, and they do prohibit lawyers from making knowingly false statements of material fact to third parties, which is ABA Model Rule 4.1. Here is what the rule says. In the course of representing a client, a lawyer shall not knowingly A. Make a false statement of material fact or law to a third person, or B. Fail to disclose a material fact to a third person when disclosure is necessary to avoid assisting a criminal or fraudulent act by a client, unless disclosure is prohibited by Rule 1.6. The language starts, in the course of representing a client, a lawyer shall not knowingly. Then, we have a couple of examples of things that the lawyers may not do. Let's look closely at this clause because each of the words turns out to be quite important. First of all, it starts off with, in the course of representing a client. Someone whose conduct has been challenged, if they are a lawyer, they are very likely to go back to the beginning and say, wait a minute, this was not in the course of representing a client. I may be an attorney, I may pay my bar dues, I may be listed on the bar website, but I am a business person. I am somebody who functions as a lawyer most of the time, but in this context, I was merely negotiating. I'm just a regular business person, so therefore the rules of ethics don't travel with me. While you could attempt to make this argument, it's very dangerous for lawyers to pick and choose when they're functioning as a lawyer and when they're functioning as a business person. In general, if you're an attorney and you are performing the role of negotiating, that's a pretty standard role that attorneys play on behalf of clients, and you should assume that your conduct is going to be subject to the ethics rules. The next key word in Model Rule 4.1 is knowingly. If a lawyer did not know a statement of fact was false at the time he made it, that conduct would not violate ABA Model Rule 4.1. The word material, obviously, is another potential escape hatch. We're also talking about false statements of fact or law. We're not talking about opinions. We're talking about statements of fact or law. So this pie is really good is going to fit into one category. And there are 3 pieces of pie when there are in fact 4. That is going to fit into a different category. And as simple as that example may sound, I think people would be surprised at how often opinions are confused with statements of fact here. And it's not just any type of statement of fact. It has to be a material fact. So it may well be, I'm happy to negotiate with you, but I have an appointment today at noon. If that's untrue, is that a statement of material fact, or is that really a statement about the context? Is that a statement about something that's not material? It may be a very bad idea for me to do it in terms of our relationship, but at the same time, is that going to be grounds for an ethical violation? I think people would argue that that kind of statement is not material. Putting it all together, you can imagine a crafty lawyer arguing in the alternative something like, first of all, this was not in the course of representing a client. Second, they'll say, well, I did make a statement, but it wasn't knowingly false. It may have turned out to be false, so they'll hinge on that word knowingly. Then they'll say, third, sure it was a knowingly false statement, but it wasn't material. Of course, that always raises my favorite response, which is, if it wasn't material and you didn't think it was going to make any difference, then why did you bother to raise it and emphasize it and stress it? While you could make all of these arguments, ABA Model Rule 4.1 actually sets out a pretty clear standard for lawyers to follow and gives us fair notice that we can face consequences if we fall short. As important as ABA Model Rule 4.1 is, the comment is arguably more important because it is attempting to unravel what it means to not knowingly make false statements of material fact in the context of negotiations. And there's a comment to Rule 4.1 that says, a partially true but misleading statement can be the equivalent of an affirmative false statement. So you can tell why I framed this the way I did. ABA Model Rule 4.1 specifically covers that type of conduct, and it would hold lawyers like Edward liable for making partially true statements that are intended to and do in fact mislead the other side. Of course, it's a lot harder to find a basis for liability or to find a basis to find someone's conduct unethical based on a partially true statement that's misleading as opposed to an affirmatively false statement, but ABA Model Rule 4.1 provides that authority. The other thing to consider is that the comment to ABA Model Rule 4.1 acknowledges the competing principle that a lawyer, in general, has no affirmative duty to inform an opposing party of relevant facts. That's probably consistent with most lawyers' views of negotiation, that because there's a general expectation of caveat emptor, there's no affirmative obligation to point out problems with one's own positions or defects in that position. The problem with that is that it gives Edward, in this case, good grounds, probably to counter any claim that he made a true but misleading statement by arguing that Kate shouldn't be taking his statement at face value. Edward might claim that Kate at a minimum should be asking follow-up questions designed to clarify or expose what Edward said as only partially true if it really was important to her in the negotiation. Let's think about what might happen here. Let's say that Kate goes to the state bar after the negotiation to make a complaint against Edward. Obviously, this is highly unlikely to happen, and that's probably one of the reasons why some lawyers feel so comfortable engaging in sharp practice when it comes to negotiations, even if their reputations will suffer. But let's say that Kate goes to the state bar and she wants to claim that Edward violated ABA Model Rule 4.1 based on his statement about never hiring a claimant as a producer. And of course, everyone's going to have a lawyer in any state bar proceeding, including Edward, whose lawyer likely would argue that if Kate cared so much about this prior idea theft case, then she should have asked at least one follow-up question about whether Silver Spoon had hired the claimant in any capacity at all. It's a logical, clarifying question. It's the thing that one should probably have heard in the statement that they hadn't hired somebody as a producer, right? A lawyer is trained to think about what might be excluded from that statement. But Kate didn't ask, and Edward didn't have an affirmative duty to volunteer that. And so it appears to me that Edward likely would get away with this. I do think it's a true but misleading statement, and ABA Model Rule 4.1 does prohibit that as clarified by the comment, but I think it's going to be a very difficult matter to prove it up. And I think that Kate is really not helped by the fact that she let it stand at face value. I think that the reaction to it may well be that a prudent lawyer would have responded to that differently. So Kate can't really rely upon the state bar to police Edward's conduct. And the state bar is not sitting at the negotiating table anyway. So we have to look at what should she do in the moment in the negotiation when Edward makes a statement like the one that he made. And she thinks, you know what? Maybe that's true, maybe it's not, maybe it's partially true, maybe it's intended to deceive or mislead. So how do we deal with that? Well, obviously asking questions to uncover and counter deceptive conduct is a great way to do it. And we've already talked about that. So let's talk about a different approach that Kate might take and what that might look like.
I understand your position. It sounds like it is based in part on your client's interest in deterring future idea theft claims. Can you tell me a little bit more about why that is important to your client?
If you've read Getting to Yes by Roger Fisher and Bill Urey, or seen one of our prior programs, you know that good negotiators usually try to separate a party's position from the interests that underlie that position. So here, Silver Spoon's position is that it will not agree to hire claimants on its shows. That's the position. If you ask questions about underlying interests, you might discover that in this case, the reason Silver Spoon has that position is because it has an interest in not encouraging people to make claims. And so that's the interest that underlies the position. Focusing on interests, not positions, is really a way in negotiation to identify opportunities for mutual gain. Indeed, if all you're doing in a negotiation is haggling over your positions versus the other side's positions, then you have a relatively narrow ring-fenced area in which you can play, right? You're essentially reduced to saying, well, if you accept my positions 1, 3, and 5, I'll let you have your positions 2 and 4. And you can make a horse trade, but that's really all you can do. And if the parties are particularly dug into their positions, then where you might end up is with no agreement at all. And, assuming that there had been an opportunity for a mutually beneficial agreement that would have been better for either party than not reaching a deal, you have a missed opportunity there. You have a broken, failed negotiation process where both parties walk away faced with a worse alternative than the one they could have reached if they had gotten past those positions and really been able to talk about their respective interests and to identify opportunities for mutual gain. By asking Edward to talk about the interests that underlie Silver Spoon's position not to hire claimants on a show, Kate may well have discovered, if she wasn't already thinking this based on her own experience, that really what underlies that position is this interest in deterring future claims. And if that's the case, then it may occur to Kate or it may occur to Edward a potential resolution of this case that's better for both parties, which is something that gives Silver Spoon its interest in deterring claimants while giving Alfonso something that he wants. And one of the things Alfonso wants is experience as a producer. So that suggests a possible resolution, actually very similar to the one that Silver Spoon used in the prior case. Namely, let's hire Alfonso as a producer on the show, thereby giving him producing experience. You don't give him a producing credit, and you make the settlement confidential. Nobody knows about it, and therefore you don't increase your risk of encouraging other claimants to bring claims against Silver Spoon. Getting past positions to interests allows savvy negotiators to come up with creative solutions that meet both sides' interests that otherwise might not be discussed or even identified in the negotiation. Had Kate not gone down this road and not asked Edward about the interests that underlie that position, this opportunity might have been missed. And they might have walked away from the negotiating table, and Kate might have had to sue, thus missing an opportunity that's really better for both Alfonso and Silver Spoon than litigation, which is rarely a better alternative to settlement for any party. So the lesson, I think, to learn is that asking the other side questions about their interests and to try to get behind positions to interest and to do the same thing yourself, to be freer in a negotiation to talk about the interests that underlie your positions, often opens up potential compromises that you might not have seen otherwise, that would be beneficial to both parties, as opposed to just fighting over positions 1 through 5. Getting to yes contains several other key insights, but it's not the purpose of this program to go into those in any great depth, because we are talking here about different ways to respond to sharp negotiating tactics. But it's difficult to go through those suggested responses if you don't understand just a little bit about what Fisher and Urey are getting at in their famous book. So, I want to just take a moment to go through at a very high level, and please do read the book if you haven't read it, because it's an excellent book, some of the other things they taught us in getting to yes. One of the other core concepts is to separate the people from the problem. We've all been in negotiations where it seems that egos got engaged, and parties start to focus entirely too much on the people sitting across the table and what they've done that was or was not appropriate in the view of the other side. Things get unnecessarily personal. And you very much have the dynamic of sitting across from the other person at the table or on the other end of a Zoom call and arguing with the person and debating, as opposed to conceptually thinking about sitting next to the person trying to mutually work on a problem. And so Fisher and Urey talk a lot about not confusing the conduct of the other parties with the problem, and to try to really focus together on solving the problem. Easier said than done, of course, but it's good advice. Another key concept is called inventing options for mutual gain. So think about any situation in which one party wants something that they highly value, that you value less. That's an opportunity for mutual gain. By trading things that you value less for things that they value more, all parties are better off. That is arguably one of the most important goals of any negotiation, is trying to find out where the parties value things differently and to trade those things. Another key principle from the book is insisting on using objective criteria. A lot of what we're talking about today are vague statements by lawyers. Things are very subjective. We're talking about intentions. So, it won't surprise you that the book suggests trying to rely upon objective criteria as much as possible, both during the negotiation and then in terms of measuring each party's performance under the agreement and whether the other side has complied with the agreement. Try to avoid subjective criteria that are going to just result in an argument either in the negotiation itself or in the performance of an agreement if one is reached. The next concept is interest-based versus positional bargaining. Another way that this is often described is the difference between integrative and distributive bargaining. Think of integrative bargaining as an attempt to integrate everybody's interests and find positions that will expand the size of the pie. And then distributive bargaining is about distributing the value in any deal between the parties. Some negotiators take the position that all negotiating is integrative. You're trying to expand the pie. Other negotiators will say that it's fundamentally zero-sum and distributive, and it's a tug of war. My own personal view is that they're both right. I think that negotiations start largely integrative, where you're trying to invent these options for mutual gain. But then at some point you do need to allocate those benefits, or the value from a deal. And you're distributing that value among the parties. So I don't think those are necessarily at odds, but the point here is to strive to have more integrative negotiations, so you have at least the opportunity to expand the pie before haggling over who gets which pieces. The last core concept that many people remember from the book is the acronym BATNA, which stands for Best Alternative to Negotiated Agreement. And essentially, if I weren't able to close the deal that we're talking about here, what is the next best thing that I can do? And it will not surprise anyone that the better your best alternative, the more leverage you have, and probably the better you're going to do in the negotiation. It's important to note that you don't just want to focus on your BATNA. You want to think about the other party's BATNA, because if the other party has no good alternatives, then of course your leverage is higher. And if the other party has excellent alternatives, then your leverage is necessarily lower. That was entirely too brief and does not do the book justice, but those are the core concepts. I wanted to go through them just briefly because they really provide the context for some of the suggestions that I'm going to make as we continue through the hypotheticals. And if you are familiar with the book or those concepts I just went through, you will think back to this moment and say, okay, that's one of the Fisher and Urey concepts that we should be following. So let's take a look at another possible response from Kate.
I'm not surprised that Silver Spoon has been accused of idea theft in the past, but I wasn't involved in any of those cases, and I'm sure you can understand why I can't take what you are saying about how you resolve them at face value. If you want me to take any of those prior cases into account, I'll need to review the relevant agreements to confirm the settlement terms.
This is a bit aggressive. Certainly Kate could make the same point without taking a pot shot at Edward's client. But what Kate is doing here, and it is something I recommend, and something that is very effective, is she's insisting on objective criteria and insisting on relying entirely on facts that can be verified. So here she's saying, unless you can show me the terms of these prior deals, I'm not going to be moved by them. And it's a very effective technique. One of the reasons it's so effective is that everyone in a negotiation worries about being sold a bill of goods, and that you're going to reach an unfair result because you were hoodwinked or you were led down the primrose path by the other side. By insisting on objective criteria, and it's whatever that criteria may be, it could be data. It could be, in this case, the results of other similar cases that Silver Spoon has settled. Whatever it is that you think objectively is a fair criteria to apply to resolve the issues in your case. Making sure that you apply that criteria and only count as part of that calculus things that you can actually see and verify is a way to make sure you don't get hoodwinked, and to make sure that you end up reaching a fair result based on that criteria. Here, Kate is essentially requiring Edward to show her the prior settlement agreements, and if she is successful in getting Edward to do that, she will discover that in this prior case with the other claimant, Silver Spoon in fact did hire that claimant to work on the show, albeit not as a producer. But she will discover what Edward was being clever in trying to conceal that fact, and that his assertion that Silver Spoon doesn't do anything like that was false. Now, of course, we would expect Edward to respond, perhaps truthfully, that that settlement agreement in the prior case is confidential and he can't show it to Kate. So what does Kate do when that happens? And again, very common occurrence, And we talked before about when people are referencing other deals. Either we never give that term or we always get that term. If you respond well, show me those deals 99% of the time, they're going to say, well, I'd love to show it to you that it's sitting right here in front of me, but I can't. It's confidential. So what does Kate do when the other side throws up a roadblock like that? The most important thing to do is to stick to your guns. You have to say that unless you can show it to me, I can't take it into account. You can soften it by adding something like, it's not about you, Edward. It's not a personal thing. Note, I'm separating the people from the problem. In order to fulfill my duty to represent my client effectively, I trust, but I must also verify. You can use that as a technique not to suggest that you think Edward's lying. Now here, Edward is sort of lying, but you don't have to say that to Edward's face. You can say, look, it's not you, Edward, I trust you, but I need to know on behalf of my client that these are actual results. So where would that leave Kate and Edward in this negotiation, if Edward says perhaps truthfully that he can't show Kate the results of the prior deal? They're not without recourse here, right? I mean, Kate is insisting on using objective criteria to negotiate a resolution of her client's claims. If you can't look at the particular deals that Silver Spoon has done in the past to settle these claims, what can you look at? Obviously, you can look at other idea theft cases, right? There are hundreds of reported decisions in which people have claimed that a studio has stolen his or her idea for a show. And those cases will either say that the claimant can recover or say that the claimant can't recover, and if they can recover, what the magnitude of the damages were. So you're going to have objective precedents that you can argue from and still meet Kate's insistence on applying objective criteria using verifiable data points in the form of reported cases. And Kate will, of course, cherry-pick the best cases where the claimant got the most money, and Edward will cherry-pick the ones where those claims were dismissed, but you're going to have something you can argue over within this concept of requiring that the criteria be objective. And that's something Kate really needs to insist on. Another thing Kate could do is insist on a representation and warranty in the settlement agreement. If it is really critical to her what happened in this prior case, maybe for some reason it's the most analogous one, or there's some relationship between the two shows, or there's some reason to believe that whatever happened in this prior case, from Alfonso's perspective, is really critical, and that's how his case should be resolved. For whatever reason, Kate could insist that in the settlement agreement, Silver Spoon represent and warrant that in the prior case, the claimant was not hired to work on the show in any capacity. If she gets that representation, then she's fine, right? She has protection in the contract if it turned out that that representation was false. And if she baked into that a right to terminate, if that representation is false. Alfonso would have a get-out-of-jail-free card if he wanted at some point to undo the settlement. A related way to do this is to get a most favored nations provision that says, you've never done it in the past, and if you end up doing it for anyone else at any time, you'll do it for my client. That's another way to deal with the problem of a potentially false representation that can't be independently verified for one reason or another. If Kate succeeds in doing either of these things in the negotiation, she's successfully transferred the risk that this representation that Silver Spoon has never hired a claimant on a show is false from her client Alfonso back to Silver Spoon, either via a representation backed by a termination right or via an MFN clause in the contract. In either case, she's done what she needs to do to protect her client and make sure that she's not being hoodwinked in the negotiation by Edward's intentionally misleading descriptions of what he did in the prior case. That's the lesson and the advice that I'm giving you here. Let's move on now to our next hypothetical.
You asked me to make you a proposal to resolve my client's claims, so here it is. We'll agree to accept a lump sum cash payment from Silver Spoon in the amount of $2 million. In exchange for which we'll give Silver Spoon a full release and agree to keep the settlement terms confidential. Do we have a deal?
What's the ethical issue here? Kate knows that Dog's Best Friend is only a moderately successful television program, and that even if Alfonso had been its sole creator, the most he could have expected to receive by way of compensation is about $200,000. Alfonso also told Kate that he would be willing to settle with Silver Spoon for as little as $25,000. So the negotiation trick or tactic that Kate is using here is called anchoring, and it's used a lot by sophisticated negotiators. Now, many of you may have the reaction, Of course, the parties are going to start off with more extreme positions, and they're going to use the negotiation as an opportunity to come together. I'm not talking about the general tactic of asking for some reasonable amount more than you'd be willing to accept, and then developing some trust and some momentum and finding some acceptable middle ground. I'm talking about anchoring in the sense of making a very aggressive, probably in many cases too aggressive, demand of the other side and using that as a tactic. This isn't standard negotiating practice in terms of starting off at one end of a relatively narrow band of values and moving to some acceptable spot in that range. This is something that is more of a psychological tactic or trick, and I think it's important to look at the psychology behind it. You can do this relatively simply, actually. Let me give you an example. If I were to ask you whether the population of Iraq is more or less than 100 million people, what would you say? Let's assume you say less than 100 million people. Now, if I ask you to take a guess as to what the population of Iraq is, just pick a number. What would you say? Let's assume you say 80 million people. The correct answer is 33 million people, but of course that has nothing to do with why we're here today. I've done this exercise with law students, and it is absolutely amazing to me how this just never fails. So, what's the trick? The first number that I gave when I asked you whether the population was more or less than 100 million people, that established an anchor in your mind. Like most people, you think that if I'm throwing a number out there, it must have some basis in reality. It can't be completely insane. It might not be the number. It might not be super close to the number, but it's not completely outside the realm. And so what happens is when I say, is it more or less than 100 million? And then I ask for an actual number. The numbers people guess are often very close to 100 million. You'd be surprised. Then I do this another way by asking half the class the question more or less than 100 million, and then by asking the other half of the class more or less than 5 million. And what you find is that if you give people the 100 million figure as an anchor, you get numbers that are in the 50 million range. And if you give people the 5 million anchor, the numbers that you get back are more in the 10 million range. Now that may not seem to be a terribly relevant example for what we do every day when negotiating. But the point is that there's some very powerful psychology behind anchoring, and you need to be mindful of this because even when we sit here and talk about it, and we all nod our heads and acknowledge that this tactic has the force of psychology behind it, it still works. And so we should try to understand why that happens, and notice in this case, I was simply asking you whether a country's population was more or less than a certain number. We weren't even negotiating, but merely throwing out a number. This shows that anchoring still establishes some kind of a baseline, even if you are now expecting me to be doing exactly that if we went through the example a second time. Let's look at what Kate did here. She throws out a number of $2 million. Everyone knows that's a really high number. Everyone knows that that is anchoring, but what is she doing? She's trying to suggest to Edward that $2 million is not a laughable number. It may be extremely aggressive, but it is within the realm of reason. Maybe she's implying that her real number isn't $2 million, but maybe it's $1 million. It's certainly not in the range of tens of thousands of dollars, which is, of course, what her client has told her he would be willing to settle for. She also may be signaling just with the number that she has a very strong BATNA. So in this case, what's the best alternative to a negotiated agreement? A non-negotiated agreement, which would mean resolving the case formally by going to court. She's signaling that she thinks that she has a strong likelihood of prevailing if they were to go to court. The thing to understand with anchoring is that, again, we're not simply talking about asking for a little more or a little bit less as the case may be. We're talking about really extreme positions. The other thing to understand is that it has the force of psychology behind it, and it can really move the other side, even if they know or suspect they know what you may be up to. Now that we've talked about and identified the trick, let's get to the question of the ethics of it. Is there anything unethical about Kate using this very aggressive anchor? I don't think it's unethical. I think I'm probably surprising a lot of viewers by giving some pretty clear answers to legal ethics questions. But I think this one is actually pretty clear. What Kate is doing with her anchor is essentially saying that this is what my client would be willing to agree to in order to settle. She's essentially making a demand and describing an acceptable settlement for her client. And as we already saw, both ABA Model Rule 4.1 and the ABA Ethics Opinion expressly say that your client's intentions about an acceptable settlement of a claim are not material facts in a negotiation context. The flip side of that being you are free to misrepresent them. So I think Kate is free to misrepresent what Alfonso would believe to be an acceptable dollar amount to settle his claims by giving a $2 million number. Now, I think we would fairly agree that she's misrepresenting Alfonso's intentions. Of course, Alfonso would gladly take $2 million if Silver Spoon were to give it to him. But the fact that he has said he would be willing to settle for as little as $25,000, I think a $2 million demand in that context is misleading, but that's okay. This could get a little trickier for Kate, however, if Edward ultimately were to respond, and let's say he put $100,000 on the table and Kate were to reject that. And then let's say Edward took it off the table, and he said, okay, well, we're done. We've offered you $100,000, you rejected it, and we're done. That could get difficult for Kate. Everybody knows that you're ethically obligated as a lawyer to communicate all settlement offers to your client. So assuming she told Alfonso, hey, they're offering us $100,000, but it's my strong recommendation that if we reject it, we'll be able to drive the price higher. If Alfonso agreed to that and said, okay, Kate, fine to reject it, nothing ethically wrong with it. But if that $100,000 proposal then vanishes and never comes back and Alfonso ultimately does worse, Kate's going to have a client relations problem with Alfonso, but not an ethical one. So I think in general anchoring is okay. Properly understood, it is just you telling the other side what your client's intentions are as to an acceptable settlement. Now, to say there's not an ethics problem with it doesn't mean that it's riskless. This is a very aggressive tactic and it does involve some risk, as we're going to see right now.
You're clearly out of your mind. Your case is so weak, I can't see advising my client to pay anything to settle, other than on a pure cost of defense basis. We could litigate this case and win for less than $50,000 in legal fees, so that's the most my client would be prepared to pay to settle.
The ethical issue here is that Edward knows Alfonso's case is strong, and that Silver Spoon already has authorized him to pay up to $250,000 to settle. Edward also knows that Silver Spoon would spend at least $100,000 to litigate the case, none of which would be covered by insurance. So Edward is anchoring right back with an aggressive counter, an artificially low number in his effort to reframe the value of the case away from something in the low millions to something in the low thousands. For the same reason that Kate's anchoring doesn't raise ethics issues, Edward's counter anchor doesn't raise ethics issues either. It's again, from his client's perspective, what his client's intentions are as to an acceptable settlement. We do need to point out, though, that once again, Edward is being very careful. What Edward does say is that his client would not agree to a settlement of more than $50,000. He doesn't say that that's his client's bottom line, and I'll talk about that in a second. Nor does he say that his settlement authority is limited to $50,000 when in fact he has $250,000 of settlement authority. Why does Edward need to be so careful about telling the other side what his bottom line or settlement authority is? Because the ABA says in its ethics opinion number 06-439 that a party's actual bottom line or the settlement authority given to a lawyer is a material fact that a lawyer may not misrepresent in a negotiation. A lawyer can downplay a client's willingness to compromise or present a client's bargaining position without disclosing the client's bottom line position in an effort to reach a more favorable resolution. That's what the ABA says, and it's been a controversial holding ever since the ABA issued the opinion. What's weird about this is if the purpose of these rules is to prevent lawyers from making misrepresentations about things that the other side is actually likely to believe and likely to rely upon to its detriment, your client's bottom line and your settlement authority are odd choices for that because generally people don't believe that. If somebody goes into a negotiation and says, my bottom line is X, it's probably the last thing you're going to believe, right? But the ABA takes a very different view. It considers both your client's bottom line and your settlement authority as those are communicated to you by your client to be facts. It's true, they are facts. They may change, but there is a present state of those facts. And if you actually misrepresent them in a negotiation, then it sort of makes sense to say, well, those are material and you just have to get over the hump of, well, would anybody ever really reasonably rely on them? And the ABA seems to say that you can. Now, we talked before about the ABA saying that you can't misrepresent these things. The ABA rules in these ethics opinions are advisory. They're not strictly speaking binding, but it's my view that whenever you get on the wrong side of guidance from folks like the ABA, you are in a high-risk scenario. In addition, most states, including California and New York, have since adopted the ABA model rules in some form, which are therefore now binding on their lawyers. If you're out there misrepresenting your client's bottom line or misrepresenting your settlement authority or the amount of an insurance policy, that's in the same sort of area, you run a pretty high risk because courts will look at these rules and at these ethics opinions to decide whether your conduct was ethical. There definitely have been situations where lawyers have been disciplined under their own state's ethics rules, or in California, under the Business and Professions Code that governs lawyers in addition to California's own adoption of the ABA model rules, with reference to what the ABA's position on these issues is. For these reasons, it's important to make sure your conduct is consistent with what the ABA says is okay and what it says is not okay. Edward is a sophisticated party who is quite careful, and he does stay on the right side of the line here by only saying what his client will agree to or won't agree to. He doesn't say it's his client's bottom line. He doesn't talk about his settlement authority. So once again, Edward escapes with his law license intact. But we should keep one other thing in mind when we're focusing on the narrow question of what types of statements do or do not cross ethical lines. Don't forget that a lawyer's fundamental duty is one of competent representation. And so I look at this example and I say, I see a lawyer who's saying that his client won't spend more than $50,000. And maybe some of that is to be expected, even if you say it correctly, as Edward has done here. But what happens if the other side takes Edward at his word? I guess there's always a first time someone actually could believe a lawyer in terms of what he says his client views as an acceptable settlement, and now the case doesn't settle. I would ask the question whether Edward has discharged his obligation to competently represent his client by saying, my client will not settle for more than $50,000. If the other side believes it, and then they find themselves in a position where they have difficulty settling, or they even may be unable to settle the case later. Now, the reality is they can always negotiate against themselves, and we'll talk about that shortly. A party can always change his or her position later. But when you are a lawyer and you are engaged in settlement negotiations, and you are bluffing in an extreme way, I think you need to be very mindful of the fact that there are real risks that could potentially cause you not to be exercising your duty of competent representation if you scuttle a potentially fruitful negotiation. Let's take a look at something else Edward might do in response.
You're clearly out of your mind. Your case is so weak, I can't see advising my client to pay anything to settle it, much less $2 million. If you want to come back with a proposal that's not crazy, I'd be happy to consider it. Otherwise, I don't think there is much more for us to discuss.
This is one of the risks of anchoring that we alluded to before. And that's why you should think about anchoring as a very aggressive strategy, and it can be met, as it was here, with an equally aggressive response by the other side. In this case, the aggressive response was a refusal to give any counter at all. I don't think there's anything ethically questionable about what Edward did in response. Remember, we talked about how there is no duty to negotiate in any particular way, including no duty to negotiate in good faith, absent an obligation under contract to negotiate in the United States. But even if there were, I think Edward could argue that Kate already breached the obligation if there were one to negotiate in good faith with her very aggressive, unrealistic anchor. The problem is that it leaves the parties in real danger of not reaching an agreement where a mutually beneficial agreement is actually possible. And that takes me back to the point about competent representation. I don't think lawyers are serving their clients very well if they take a matter that can be resolved to the satisfaction of their clients, and because of their tactics, they turn that into a situation that can't be resolved. Anchoring is very risky because it can generate exactly this kind of a response. If you want to employ the tactic of anchoring, one might say don't anchor so aggressively that it creates the risk in your mind of the other side simply not acknowledging it or giving you no credit for it. I've heard the expression after somebody makes a very extreme proposal, and then the other side says, well, that's like coming into my house and saying, you want to buy my house, and my opening offer is $1. You don't negotiate with that person. You think they're crazy, and so there is no negotiation. Obviously, you can't go in and offer $1 because you're never going to start a negotiation that ends with the parties meeting in the middle, as they say. There just won't be a negotiation. So you have to make a proposal, if you are anchoring, that is reasonable, in the sense that it's going to generate some momentum, generate some traction, keep the negotiation going, keep the parties at the table having a discussion. This is not a program in terms of giving advice on how to engage in sharp practice. It's a program that's designed to help you identify sharp practice and how to deal with it. If you're on the other side of somebody who's engaged in what you regard as very extreme anchoring, and you don't want to be influenced by it, one possible response is to not acknowledge it at all, or to identify it for what it is, which is just an extreme and unrealistic anchor, and essentially say, I'm not giving you credit for that proposal. That's not a real proposal. If you have a real proposal that your client wants to make, let me know. That's exactly what Edward did in this case. In response, Kate has to decide what to do when she hears Edward say what you just heard, which is that he isn't willing to pay anything, much less the $2 million that Kate is demanding. And this is a real box. And it's another risk to the party who is engaging in the extreme anchoring if it's too extreme. Once Edward says that he's not giving her any credit for that proposal because it's not realistic, now Kate has to make a decision. What do I do? Do I do nothing and wait and say, it's your turn? I offered $2 million and now it's your turn. So you can give me any number, but I'm not going again. Or does she do the dreaded negotiating against oneself, which is a classic saw of negotiation, is that you don't negotiate against yourself. You don't make consecutive offers or proposals without movement from the other side. Another possibility here to get out of this dilemma is to end the negotiation and simply call Edward's bluff and file the lawsuit and see if that act actually brings Edward back to the table. What's the lesson here? When the other side engages in very extreme anchoring like this, and it's not enough to keep the dialogue going, it's very high risk. It gets egos engaged. It becomes very contentious. And clearly as a lawyer, we all need to be extremely careful before engaging in this conduct. What happens when the other side does this? What are some of the options? One tactic I've actually seen is somebody comes back and says, I actually threw out that first number, which I acknowledge was a very, very high number, just to see if you were paying attention. So clearly you're paying attention. Now here's my real number, and here's why it's reasonable. Sometimes if you say that quickly enough and there's an element of humor or levity to it, it can actually be effective. And in that particular case, it did keep the dialogue going. We didn't need to make an offer in response to it, but it sort of got the person giving the very aggressive anchor out of that box of being stuck where they didn't want to negotiate against themselves very quickly. In that case, yes, it's true that they had to backtrack a little bit from an unsuccessful anchor, but it was at least something that didn't prevent the dialogue from continuing. The other tactic that I've seen people use with some effect is to say, based on the facts as I see them, I've seen cases like this go for X dollars, and X is a very extreme number, but we're not in here asking for X as the very extreme number, even though we think that's a reasonable basis. We're asking for some other number that's lower. So even though you're not actually asking for that number, you are at least using it psychologically or conceptually as a reasonable anchor. And you're sending the message that you've already sort of made one move in the negotiation that might influence the other party to counter at a higher number than they otherwise would have on the theory that you're already 2 moves into the negotiation. Let's take a look at what else Edward could say in response.
Kate, I'm very surprised by the size of your demand. Can you explain exactly how you calculated your $2 million demand and exactly what precedents you believe support that figure?
Of course, there's no ethical issue with asking questions. And what Edward is doing here is really pushing Kate to explain the basis for her $2 million demand with respect or regard to objective criteria, that is, precedents or other things that you could point to and verify. This comes right out of getting to yes, similar to what we saw earlier. It's a really good way to counter an anchor or really any position in a negotiation that you feel is potentially misleading or lacks a basis, because if you set up as a ground rule that you're only going to decide this issue with reference to objective criteria, then there has to be a reason and a basis for the positions taken by the other side. And if you can get the other side to buy into that and insist on it, then that's a good way to counter an aggressive first offer or really anything that doesn't sit right with you. Asking questions generally also leads you to a conversation about interests in the negotiation, not positions. And that's valuable for all the reasons that we talked about before. It identifies potential opportunities for mutual gain, things that you can trade off that you value less than the other side does. Here, Alfonso may want money. I mean, who doesn't want money? And I'm sure he wants money, but perhaps if you get past the position of, I'd like a check for $2 million to the underlying interest he has, maybe his interest is really in just being recognized, getting some recognition for having come up with the idea for this show. And if that's at bottom what he wants, then maybe a little money, not $2 million, but something, plus a producer credit, or maybe even just a press release that Silver Spoon issues that acknowledges in some way his role in the development of the show, those things collectively would meet his interest in feeling that he's gotten adequate recognition for his contribution to the show. If Edward doesn't ask these sorts of questions, then he may never discover opportunities to give Alfonso something other than money. And if Silver Spoon values money highly and values giving someone credit or issuing a press release less highly, the opportunity to trade those two things off might well be missed. Let's tackle our next hypothetical.
Edward, my law firm represents some of the biggest names in Hollywood, and as you know, this is a relationship business. The only reason we're representing Alfonso in this case is because he's the son of my law partner. If you won't do right by Alfonso here, I'll make sure everyone in this town knows just how unreasonable you are.
What's the ethical issue here? Kate is threatening to badmouth Edward to her other clients and to other counterparties in order to punish him for the positions that he's taking in the negotiation. This tactic is sometimes called co-opting or undermining the other side's negotiator, and it's a very personal tactic that is aimed at the specific representative of the other side. In many cases, it will be the lawyer. And if you think about it, it can really be done in one of two ways. We can use the classic carrot and the stick. Let's start with the stick, which would be threatening to badmouth Edward if he won't give her a better deal. And this is what's happened in the example we just saw. Another way, we might call the carrot, and that's offering to help Edward in the future if he agrees to help Kate in this deal. In either case, what's really going on here? At bottom, what's going on is that Kate is trying to drive a wedge between the other side's negotiator and the client in order to get a better deal from the client. Clearly, it's a conflict of interest, right? And we can talk about whether it's ethical or not to try to generate a conflict of interest for the other side. But if the representative were only looking out for their client's interests, none of these carrots or sticks that are personal to the representative would even matter. If you think about threats and the way that these things work, they happen in any number of different ways, right? You can talk about bad-mouthing people. You can say, I'm going to refuse to do deals with you for other clients. There's also the opposite of that, which is somebody who's trying the carrot and trying to kill you with kindness. Somebody's offering to introduce you to someone who's important, who can maybe help you professionally, help you get a new client, help you get a new job. Maybe they can help you with something of a social nature. Maybe there's some country club that the attorney's trying to get into or some other exclusive social circle. And these things don't necessarily come up expressly. I don't think that people are going to say, if you help me here, I'm going to do this particular favor for you as an express quid pro quo. But simply having a discussion about some social club or maybe it's some exclusive school or some other opportunity and how the person on the other side knows people who can be helpful, it starts to drive a wedge between the interests of the client on the other side and the attorney. Of course, it's particularly dangerous because often neither your client nor the party on the other side will have any idea that it's even happening. One reason I created this hypothetical is because this has happened to me. I've had a lawyer on the other side tell me that I was being too aggressive in a negotiation and that this is Hollywood and it's a relationship business. And you're doing yourself a disservice, etc., etc. I didn't end up playing any nicer with him in that negotiation. I can be quite stubborn that way. And actually, a couple years later, when I was at a different company in a different job, I had the pleasure of firing that lawyer's law firm from working for my new company. So I think a lesson learned here is when you make threats, people tend to remember those, and often they'll be in a position later to repay you for having threatened them. So I have a strong opinion about the morality of doing something like that, but let's take a look at the rules. Is this conduct ethical? Making threats or offering carrots designed to drive a wedge between the other side's negotiator and his or her client is certainly not good faith negotiation, but we know that that's not the standard. Good faith in negotiation is not required. Of course, if Kate had offered Edward a cash payment to him in return for her agreeing to something more favorable, or if she had in some way threatened his family with violence, either of those things would be not only ethical violations but felonies. The problem, though, is short of that, this sort of thing happens all the time. People making threats or promises to folks in negotiations in an effort to influence the negotiator, separate from influencing the merits of the negotiation with the client. And I don't think that there's really much that the law or the ethics rules can do, either to deter that or to remedy it, if it does happen. So really where that leaves us is that you, as the negotiator who's faced with these sorts of things, number one, you need to recognize it. You need to understand when it's happening to you because, as I said, it can be more subtle. It's often not the express quid pro quo. If you agree to this point, I'll get your child into fancy private school A. It's more, hey, we're friends now, and you may talk about those matters at the same time you're talking business, and the link is more implicit. But second, to resist being influenced by it, because what's really happening here is they're trying to create a conflict of interest between you and your client. If that happens, and if you're not able to resist it, your ethical obligation becomes disclosing that conflict of interest to your client and getting your client to waive it, and that rarely ever happens. And you never want to have to go to a client and say, okay, I've been compromised here by my relationship with the lawyer on the other side. You must do it if it happens, but no lawyer wants to go in and say, well, I feel like I have to give Edward a better deal here because my child is applying to the school where he's on the board. Nobody wants to be in that situation. So what you need to do is resist any effect that that can have on you. And if necessary, remove yourself from the negotiation. Often, there's more than one lawyer that could handle it. If you really feel like you can't identify and properly disregard any potential conflict of interest that the other side is trying to create. So how should Edward respond? I think the first thing is recognizing it and resisting it in principle. Let's take a look at what that would look like.
Kate, you should know that I never yield to threats, but I'm happy to focus on the merits.
I like this response for a couple of reasons. First of all, it's principled. It's not really based on tit for tat or responding in kind, which is very often the worst possible thing because if you make a threat back, the situation gets escalated, and you may find yourself in a situation where something that can be resolved is now something that can no longer be resolved because the representatives have disserved their clients by escalating the situation to the point where everyone takes their toys and goes home. So when possible, I think it's better to simply identify the conduct and resist it on principle. And everyone has their own style. In this situation, Edward says, you should know that I never yield to threats, but I'm happy to focus on the merits. Now maybe that's a little bit formalistic in terms of response, but I like the message. The message is, essentially, this is not about me personally. As a lawyer, this is not about my interests. I'm trying to focus on my client's interests. You could say it like this. You'll understand that I can't let something you're telling me about what's going to happen to me personally, as a representative, influence what I do on behalf of the client. You're going to do what you're going to do, and I'm sorry if you feel the need to badmouth me or do any of those things, but it's not going to have any impact on what I do on behalf of my client. That's where I owe my obligations, I'm sure you understand. Of course, people have different styles. Another possible response here is to respond with a little bit of levity. And when they say, I'm going to make sure that everyone in town knows how unreasonable you are, you could simply say, well, you don't need to bother. Everyone in town already knows how unreasonable I am, and you telling them again isn't going to accomplish anything. The point here, I think, is to diffuse the situation if you can. Definitely don't escalate it. And then I would say the middle ground is if it sounds like a serious threat, just to call them on it. Just say, I understand what you're trying to do here, and you can appreciate that I can't let that impact what I do on behalf of my client. Let's take a look at some other possible responses.
Kate, if you threaten me again, I am going to file a complaint against you with the state bar. I'm sure they will be very interested when I tell them about all of your misconduct during our negotiations.
This is probably the worst possible response from Edward, as it is an ethical violation in many states to threaten to file a disciplinary complaint against another lawyer. With respect to ethical complaints, you either have to file it or not file it. You can't threaten it. And so that would be the worst thing that Edward could do. Setting that aside, another thing he probably should do is, in addition to resisting on principle, is have a conversation with his client to basically say, look, here's what happened. We're holding firm on this issue, as you and I have discussed, and it makes sense for us to hold firm because we need to adequately deter people from bringing claims against us. And we've offered what we think is reasonable and we're not going to move on it, but here's what may happen. They're basically saying that they're going to badmouth me and make it more difficult for us to do deals with other talent around town. And that if you believe that they may have some success in that, it could harm our business. But as we discussed, it's the right answer for the studio not to negotiate with terrorists, and we're not going to negotiate with people that threaten us. And just to make sure that you and I are on the same page with regard to the line that I'm taking. If you have that conversation with your client, nobody's going to say you should negotiate with terrorists, and nobody's going to say, well, we should do the wrong thing here instead of doing the right thing. I think from a client relations standpoint, that's the right way to handle it. And in case there is blowback, you want to be prepared. Clients hate surprises. That's the lesson I've learned probably the most often in my career. And so, as long as everybody is aware of the possibility that this could result in some blowback, you generally won't have a client relations issue at the end of the day. Let's move on now to our last hypothetical.
Edward, we accept your last proposal, and we are now closed. I've already started on the settlement agreement, and I will send over a draft to you later today.
What's the ethical issue here? In the draft settlement agreement that she sends over, Kate includes a provision requiring Silver Spoon to pay $10,000 to cover her client Alfonso's legal fees. Kate never raised the issue of who should pay her legal fees in the negotiation, and it was not included in the last proposal that Kate told Edward she was accepting. I call this next level trick the nibble. And what it means is that a deal is ostensibly closed. In this case, they actually use the word closed, but there are now other requests, demands, revisions, clarifications, things of this nature that sweeten the deal a little bit for one of the parties. And the reason that we call it nibbling as opposed to biting off, I suppose, is because they're not really significant in the sense that they are not material in amount when compared to the other terms that have been agreed. There are small things, and very often, by the way, if it's a small thing and the other party says yes, it usually yields more small things until the other party stops agreeing to them. So this is why people do it. They feel like there's very little cost to asking for these additional things. What's the worst they can say? They can say no. And the other side, once they think that the deal is closed, there's a certain amount of psychology of they've moved on, maybe they have some deal fatigue, maybe they've reported to other people that the deal has been closed and they now have some pressure, internal pressure, or just psychological pressure to move on and they don't have the patience to fight any longer. And they are always under the impression that if they just agree to that one nibble, then everything is done. And of course that's part of the fallacy is that it's just one nibble, it's almost never just one nibble. So in this case, the settlement calls for Silver Spoon to make a pretty substantial cash payment to Alfonso, plus this additional $10,000 in legal fees. I would still say it qualifies as nibbling because it's secondary to the primary point of the agreement that they've negotiated. So of course we want to ask, is that ethical? With the same caveats as before, that is, there's no general duty to negotiate in good faith. I would say that nibbling is okay here because it's not a false statement of material fact. What you can't do is make a knowingly false statement of material fact in a negotiation. And what Kate is really doing here is making a counterproposal, albeit a counterproposal made after Edward probably reasonably thinks, based on what Kate said, they were closed. They had a deal, but that's really what Kate is saying is that we'll take that deal if you just give me this little additional thing. Now, could you claim that Kate's statement that we are now closed is a false statement of material fact? Particularly if Edward then refuses to agree to the nibble and the deal falls apart. There are two separate issues that I would want to think about here. The first is whether the oral agreement that Kate and Edward reached to settle is an enforceable oral agreement to settle. Now, what that would depend on is whether they had reached a deal on all material terms and whether that deal was sufficiently definitive for it to be enforceable. That's a civil law issue. Whether you have a meeting of the minds and whether an oral agreement is enforceable, that's something that's going to turn on all of those facts. Now, a lot of times you don't have that litigated because if you have a situation like this, where Edward thinks they were closed until Kate asked for this additional thing, Edward isn't going to run to court and try to enforce an oral agreement to settle. He's going to think that's a risky proposition, right? He's not going to want to spend the money or incur the risk that they don't actually have a deal. Rather, he'll just take the position that they didn't have a deal and it never gets litigated. So that's one issue. The second issue is whether or not they had an enforceable oral agreement to settle. Is it an ethical violation to breach an oral agreement to settle? And I think the answer to that is a clear no. Civil liability is distinct from liability under the ethics rules. And we've all had situations where we've negotiated a deal on behalf of a client, or the other side has negotiated that same deal, and ultimately one party ends up breaching it. There could be many, many reasons why that happens. Sometimes it's even efficient to breach a contract, rare, but in other cases it just happens, or there's allegations that a contract has been breached. It doesn't mean the lawyers, when they shook hands and said, "Hey, we're closed," committed an ethical violation. It's just a different standard. So, even if Kate had said, "We're closed," and whether or not that oral agreement is enforceable, the fact that Alfonso later chose to breach that contract isn't going to mean that Kate committed an ethical violation. The other thing I would say is that this happens fairly frequently, and it has a lot of different flavors. Whether you call it nibbling or you don't, there's always the concept of, hey, we've got a deal on a term sheet or a set of 5 points that we've talked about orally or some version of that. Then there's a step of reducing that to an actual contract that the parties can sign. We've all seen deals that have fallen apart at that second stage. When you are discussing the legal points, often you come to loggerheads about language that one side wants, the other side won't agree to, and if you can't find a resolution of that, the parties don't sign the agreement and the settlement goes away. I think that it would be hard to say that Kate saying we're closed on the material deal terms and then coming back and trying to get a little more is unethical, given how common that is in negotiations, and given how parties always have to negotiate the legal terms before they can sign a settlement agreement. Until the ink is dry on that settlement agreement, you're in the zone of, we've got a deal, a tentative agreement to settle, but things are still going to need to be worked out on either side before it's done and dusted. How might Edward respond to Kate's nibbling? Let's take a look at one possible response.
Kate, I read the draft settlement agreement, and it includes a $10,000 payment for your legal fees that was never discussed, much less agreed. Please give me a call so we can reopen our negotiations to see if we can reach a deal.
Here, Edward is threatening to reopen the negotiations and presumably to take something of value off the table in response to Kate's request for legal fees. In other words, he's responding to her nibble with a general implication that there now is no longer a deal. Now, it's a good strategy in the sense that it can prompt the other side to withdraw the nibble and get back to the original deal that you thought you had. But understand that if you say you're reopening negotiations, you potentially could undermine a position that you could have taken instead, namely that there was in fact a closed and thus enforceable deal. So be careful in terms of the language there. Another thing that Edward might do is to reciprocate with a counter nibble where he comes back and asks for something that is presumably bigger than the ask Kate had. The idea is to show that there's not going to be a one-way spigot in which all of the new additional value flows in the direction of Kate. Edward is maybe prepared to talk about some trades, but they're not going to simply water down the value of the deal during the process of trying to paper the deal that had been agreed to earlier. Now, sometimes there's not such a big problem with this. There's nothing necessarily wrong with having new issues come up in the formal drafting, and there may be positions that are traded in that process. But the difference between a nibble and simply new terms that come up in the drafting of a contract is that nibbling implies that a party understands that it's making a new substantive request that wasn't discussed before. It's not the kind of thing that would just naturally flow in the context of finalizing a written agreement. It's not asking for a standard representation and warranty, integration clause, or confidentiality provision. Those things aren't nibbles. That's simply clarifying and fleshing out the terms of the deal so a written agreement can be drafted, finalized, and signed by the parties. Nibbling is when you're really asking for something that is new, that, in all fairness, should have been discussed before, and the parties would have expected to be discussed before. So it's also not the case that agreeing to a nibble is necessarily wrong. It can make sense sometimes to agree to it. So let's say, for example, that the request is for $10,000, but the party receiving that request has another concern about the confidentiality provision, and they want it to be particularly tight. They want enormous liquidated damages, for example, and they know that they're going to make that ask. So you could potentially be trading things like that. The one thing that you've got to be very careful not to do is to fall into the trap that we talked about before, where you start thinking about the relationship that you may have with the other lawyer. When the lawyer says, you know what, I need $10,000 for my legal fees on this one, You and I are going to see each other on other deals, and I really need you to do this for me. What goes around comes around, and I need you to take care of me here. Now, we're talking about interests that don't relate to the clients themselves. Now we're talking about interests that relate to the lawyers. And in each individual representation, the lawyer owes a duty of zealous advocacy and competent representation to just that client, and they can't water down the services or the fiduciary obligations that they owe to an existing client, just to try to preserve some goodwill for a future deal. So, be very careful when you face a nibble, and the other side says, "Listen, I need you to live with this nibble because we're working on a lot of deals together, and I'm sure it's going to come out in the wash." Focus only on the interest of just that one individual client. It's time now for a summary of what we've covered today. We've seen in the course of today's presentation the general rules that require lawyers to be candid in their dealings with others. That's ABA Model Rules 4.1 and 8.4. While lawyers are expected to be zealous advocates, you are not required to press for every advantage, and you certainly can be reasonable in negotiating. You can take an interest-based approach to negotiating, which many top negotiators, myself included, recommend, and you're not required to fight over every last dollar. You can negotiate in good faith, even if you're not legally or ethically required to do that because you believe that produces better agreements. But there are certain pretty clear bounds that you still have to stay within. And that's really bounded by these rules, and then to a lesser extent the ethics opinions that help to interpret the rules, but they themselves are not binding. I also cautioned you, particularly those of you who practice in California, about some provisions in the California Business and Professions Code that exist and are binding, and that contains some pretty sweeping language that bars attorneys from being dishonest that could trip you up even when other authorities like ABA Ethics Opinion Number 06-439 suggest that certain conduct in the context of a negotiation would be okay. In that regard, we do have some specific takeaways. Clearly, you may not misrepresent your bottom line or the settlement authority that you have been given. Better to speak of your client's inclination toward a potential agreement and not his or her bottom line. What else have we learned that is clear in this area? The rules do not expressly bar attorneys from misrepresenting facts or law if they are not material. The rules also don't prevent attorneys from misrepresenting opinions or intentions or state of mind. Those are other categories of things that if you're negotiating with someone and they're making statements about their state of mind or their intentions or their opinion, you want to be thinking about the fact that those may not be true. And in fact, if they're not true, it's not going to create an ethical problem for the other side. The rules also do not preclude lawyers from misrepresenting their settlement positions. Different from bottom line, but their settlement positions clearly can be misrepresented. You want to be very careful when hearing statements like that. And that also includes statements about that side's willingness to make concessions. If you hear an attorney claim that their client is not willing to make any concessions, you can hear that and know that it is not going to be an ethical violation, and it very well may be misrepresented. There are other takeaways that I'd like you to have, not simply where the rules of ethics draw lines, but more practical advice about listening very carefully to the representations that are made to you, asking follow-up questions, always pushing and pushing to clarify statements that are made, asking questions to try to discover the other side's interests. All of those things are going to help you avoid being deceived when misrepresentations are being made to you in a negotiation. This brings us back to ABA Ethics Opinion Number 06-439, which is the most direct treatment of the question that we're talking about today. What ethical rules apply in negotiations? That opinion says that the lawyer you are opposing may, without violating the ethical rules, misrepresent her client's goals, the client's objectives, the strengths and weaknesses in the client's position. The value of the subject matter may also be misrepresented to you, and the lawyers you're facing may also misrepresent their confidence in the availability of alternatives. When thinking about BATNAs, always remember you're not the only party that has a BATNA. If you spend all of your time trying to figure out what your alternatives are, you'll be doing exactly half of the analysis that you need to do. You also need to think about your opponent's best alternative to a negotiated agreement. Finally, to the extent that you're negotiating a deal on behalf of a client, presumably the goal is not to reach just any deal. The goal is to reach a durable and enforceable deal, and your client is not going to be well served by engaging in conduct that, if it's discovered later, threatens the durability or the enforceability of the deal that you've reached. The client wants to be done with you and your legal fees the minute the deal is done, and they don't want to face the risk of a lawsuit for rescission or fraud or anything else. The fact that you're being ethical as a lawyer really just falls in line with how you should behave generally, both to preserve your professional reputation and to best serve your client's interests. I hope you enjoyed today's program, and thanks very much for joining me.